morning.
Good morning. How's everyone?
Good. Hold on one moment. Okay, I think we have Mr. Solis in.
Yes.
All right. Excellent. We're here on the case of Reinerston versus Solis. Case
Yes.
DR774. Please enter your appearance, Ms. Bocher.
Good morning, Your Honor. Tony Botcher on behalf of the former wife and mother, Sarah Sabalas.
Okay. Not wife.
All right. And Mr. Solis, are you represented today?
I am not, Your Honor. Oh, sir.
Okay. Who's LG Stylo 6?
I'm not. I don't know.
I don't know.
All right. Good morning. What case are you here for? You're on mute. LG Stylo 6. Good morning.
Hello?
Hold on. Good morning. What case are you here on?
Hi, good morning.
Hi, good morning. What case are you here on?
No understand.
I'm sorry, what?
No understand.
I think she's saying she doesn't understand.
Okay. All right, I'm gonna put you in the waiting room because I think we're on a different case. All right, now that that's out of the way, we ready to proceed?
We are, Your Honor.
Yes,
all right,
sir.
Ms. Bocher, please, we're here on the motion to compel.
Yes, very briefly, Your Honor. An income withholding order was entered in this case on October 8th of 2012, which provided that $313 in monthly child support and $75 towards the arrears be deducted from the father's pay. And just so the court knows, the child is now emancipated. We're here only on arrears. In June of 2018, the mother filed a motion for contempt. And at that time, the father had child support arrears of nearly $50,000. The parties ultimately entered into a settlement agreement in September of that year, and that agreement provided that an amended income withholding order was to be entered to change the father's payment towards the arrears of to $200 monthly. That order was never entered. The agreement also provided that a subsequent income withholding order was to be entered after the father's child support obligation terminated, requiring $600 a month to be withheld, and that also was not entered. Also pursuant to that agreement, the father was to pay the mother $2,500 towards his child support within 30 days, $10,000 towards his arrears by October of 2019, and $500 towards the mother's attorney's fees within 30 days, was a total of $13,000. And the father never made any of those payments. As of February 5th, which as the court will see in evidence, it was the latest amount we were able to get from DOR, the father owes the mother child support arrears of $48,000 and some change, plus $500 for her attorney's fees pursuant to that agreement. And of course, she's incurred additional attorney's fees for having to file the motion. After she filed her motion to compel on March 4th, we filed a request for an updated financial affidavit pursuant to 12.287, and the father did not provide the requested financial affidavit. We filed a motion to compel on March 29th. Obviously, we couldn't have a hearing on that held before this one. He still hasn't provided that. The mother also filed a request to produce on March 4th, and the father hasn't provided those requested documents. So the mother's just requesting that the court take judicial notice of the request for updated financial affidavit, the motion to compel related to that, and the request to produce.
Okay. All right. Mr. Solis, before we get into any testimony, do you have a response to the motion?
Yes, as soon as I got the letter from her attorney, I reached out to them and I asked her, which was the best way to get rid of this situation so that I can just get caught up with everything. I asked if I can get an extension so that I can see if I can try to retrieve some money that I had invested in Texas, in which she said that she would try to contact her client. Then she got back to me and she said that she wanted $10,000 and that she will like all these will go. She would not file anything else. She wanted $10,000. I told her that I needed to go to Texas to see if I can retrieve the money. And she said, well, how much can you give her? And at this point, I have a check that I already, a cashier's check that I'm gonna send for $4,300 today on the mail. And I also said that I did not want to get an attorney because I would rather pay anything that I had to pay, any money that I had, I would just pay her instead of hiring an attorney. I did explain to her too about the situation about I don't have any, I can, I was truthful when I say I do not have anything in my bank accounts. I do not have anything as far as like what they asked me for, like any loans, any debt, anything that's owed to me, anything. I pretty much, I depleted all my resources because I am currently helping out my family because I lost 2 people that were really important to a family from COVID-19 that I'm helping out.
You know what, Mr. Solis?
Yes.
This kind of went into testimony.
Okay.
And I just needed to understand whether or not you agree or disagree with the relief being requested. So here's what I'm going to do. Obviously, this needs to go to testimony. I'm going to have the clerk swear in both parties, and we'll proceed on that basis. Madam Clerk, could you please swear in both Ms. Savalas and Mr. Solis?
Please raise your right hand.
Okay.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
I do.
Yes, I do.
Okay. Ms. Bocher, this is your motion. Please proceed.
Thank you, Your Honor. Ms. Savalas, will you state your full name for the record, please?
Sarah Savalas.
And are you the former wife and mother in this action?
Former mother, yes, not wife.
Former mother, yes, my mistake. And Your Honor, I'm gonna share my screen. Oh, I actually did that well. I'm getting more adept at this, Your Honor. Ms. Savalas, if you'll turn your attention to the screen, I'm showing you what's marked as Exhibit 1.
Yep.
Okay. And do you recognize this as your motion to compel?
Yes,
Motion for enforcement? Okay. And attached to that was a settlement agreement. Do you recognize that document?
Yes, I do.
Okay. Is that a true and accurate copy of the agreement you entered into with Mr. Solis?
Yes.
And to the best of your knowledge, is that the most current agreement in your matter?
Yes.
Okay. Has Mr. Solis paid any of the $13,000 owed to you pursuant to the agreement?
No.
Were the income withholding orders set forth in the agreement ever entered?
No.
Do you know why?
I do not.
Ask the court to move Exhibit 1 into evidence, please.
Any objection?
Well, I am not, at that time, we were having issues with payroll. And actually, I did try to up the amount back to 600, but I wasn't able to because we switched payrolls 2 times.
The only question is, do you have an objection to the court admitting this exhibit?
No.
All right. This Exhibit 1 will be admitted.
Your Honor, court's indulgence while I get to my next exhibit. Okay. Ms. Savalas, if you will turn your attention back to the exhibits, please. I'm showing you what's marked as Exhibit 4. Do you recognize that document?
Yes.
And is that the document from the Department of Revenue pursuant to our request?
Yes.
And turning your attention to Exhibit 5, which should now be on your screen, is that the family law case history that was obtained from the Department of Revenue?
Yes.
Is that an accurate depiction of the total arrears due?
Yes.
Your Honor,
I thought the money was down to like 43,000. That's what you told me.
Okay. That's do you have an objection to the testimony, or do you have an objection?
Yes. She actually went over when last time I spoke to her. She actually checked when she got the from the court records, and it shows that it's like down to like 43,000, not 48,000.
Okay. The objection is overruled.
I'm asked that exhibits 4 and 5 be moved into evidence, please.
Any objection to exhibits 4 and 5 being admitted?
No.
Exhibits 4 and 5 are admitted.
Ms. Sabelis, have you discussed the payments due to you with the father? Ms. Sabelis, can you hear me?
Yeah, I can hear you. I said no.
Oh, I'm sorry. I didn't hear you. I didn't hear you. That's my mistake.
Right.
What, if anything, do you know about the father's lifestyle?
Objection. Why would my lifestyle be anything to do with her child support?
Overruled.
You may answer.
So just based on, the interactions he has with our son, he has been, four-wheeling, having boats, lives on Marco Island, with his family in a nice home. So I do believe he has the ability to pay.
And what, if anything, do you know about the father's employment?
I know that he, to my knowledge, works for some family members who have, obviously not been, or my understanding, not been adhering to these orders despite my outreach prior to the past year. So hence, I believe a lot of his income is likely given under the table via cash. So it's unfortunate that none of this has been updated.
Are you asking the court to require the father to complete community service?
Yes.
Are you asking the court to require him to pay a purge in the amount of $13,000?
Yes.
And that is the same amount he agreed to pursuant to the current settlement agreement, correct?
That is correct.
Are you asking the court to suspend the father's Florida driver's license?
Yes.
Are you asking the court to enter a money judgment in the amount of $48,248.29 with interest to accrue?
Yes.
Are you asking the court to award your costs and attorney's fees incurred in filing this motion?
Yes.
And I'm going to show you what's marked as Exhibit 6. Do you recognize this as your affidavit of attorney's fees and costs?
Yes.
And I'm going to show you Exhibit 7. Do you recognize these as your redacted billing statements?
Yes.
Okay. And just to be clear for the court, the only reason that you engaged our services was related to this motion, correct?
That is correct.
And we've not provided services to you beyond what was needed for this motion.
That is correct.
Okay. And does the redacted billing statement, is that accurate? Does that reflect your fees until March 18th of this year?
That is correct.
Okay. Have you incurred fees related to the motion since March 18th?
Besides the conversations that we've had?
Yes.
No. Yeah.
But you have incurred fees in addition?
Yes.
Not including today's hearing, how much have you incurred in fees since March 18th?
I'm not sure.
Do you believe it would be around $700?
Yes, based on the number of times we've interacted, yes.
Okay. All right. And just to be clear, the settlement that agreement that you entered into in September of 2018, that was an agreement worked out between you and Mr. Solis, correct?
That is correct.
Objection. That was an agreement between you and I. I never spoke to her about it. And if I recall that, you gave me...
That's not a legal objection, Mr. Solis.
Okay.
So the objection's overruled. You're going to have an opportunity to testify, Mr. Solis, just so you know.
Okay. All right.
Should you choose?
Your Honor, I'd ask that Exhibits 6 and 7 be moved into evidence, please.
Any objection to Exhibits 6 and 7 being admitted into evidence, Mr. Solis?
No.
Exhibits 6 and 7 will be admitted.
Thank you, Your Honor. Your Honor, will the court rely upon my invoices as sufficient to satisfy the lodestar requirements as to the reasonable number of hours?
I don't know yet. Please proceed. I'm not going to make a ruling on that right
No,
now.
no. I'm just asking or would you like to hear my testimony as to those hours? I'm not
I don't
asking.
have to hear your testimony.
Okay, that's all I'm asking. I'm not asking if you're under the work fees. Okay. As to the reasonability factors, the issue before us is not novel or complex, but obviously did require sufficient information. And it didn't have any impact on my hours.
We don't have to. We don't need to get into any argument right now.
Fine. Okay, that's all I have for this witness. Let me stop.
Mr. Solis, this is your opportunity to ask questions of Ms. Savalos based on her testimony. This is cross-examination. I know you're proceeding unrepresented. You have an opportunity now to ask questions if you would like. You don't have to, but if you would like to ask questions based on her testimony, this is your opportunity.
The only question I have is, when I did speak to her attorney, it's not $48,000. It actually, the number actually has come down. That's number one.
Do you have a question? Do you have a question for Ms. Savalos?
No.
Okay.
No.
All right. Ms. Bocher, do you have any other witnesses or evidence to present?
Court's indulgence for just a moment. I'm going to call Mr. Solis, please.
Okay. Mr. Solis, you are under oath. Ms. Bocher, please proceed.
Mr. Solis, where are you currently employed?
Morca Construction Services.
I'm sorry, I couldn't hear you.
Morca Construction Services.
And are you a full-time employee?
Nope. Half-time. As of like 8 months ago, half-time. Part-time.
How are you paid?
Payroll checks.
Do you receive any cash payments?
No. Every once in a while, I might receive a bonus, but it's not cash payment for payroll purposes.
What do you mean by that?
It's a bonus. It's not a payroll check. It's just a bonus.
Is it paid to you in cash?
No, it's paid in check.
Is it included as income?
I'm not sure if a bonus is considered an income.
Okay. You currently live on Marco Island, do you not?
Yeah, but I don't know where the place you live really considers to anything to your financial situations.
Just answer the questions, Mr. Solis.
Yes.
Isn't it true you own a boat?
No.
Isn't it true you own a vehicle?
It's a provided for work vehicle.
Isn't it true that you have recently taken a vacation?
I don't know what you consider a vacation. No. Like, what is considered a vacation?
What do you consider a vacation?
Somewhere where you leave town or you leave the country.
Have you taken any trips lately?
Have I taken any trips locally?
What was that trip?
It was one night, and I guess it's considered a place where you go and ride ATV vehicles.
And you said you stayed overnight?
Yes. But you stay in the woods. It's not a resort.
And true, you did not pay the $13,000 to the mother that you agreed to pay in September of 2018, correct?
Yeah, I guess I have not.
When you voluntarily entered into that agreement in September of 2018, did you not?
Was it you that I went into that agreement with?
No, sir, I was not involved in the case at that time.
You weren't her attorney back then?
I was not involved in the case at that time, no.
Okay, well, I did go into that agreement, but I should have had counsel because, well, should I continue or?
No.
Okay.
Nothing.
Basically, I went into the agreement not knowing what I was really signing. I should have had a grand counsel because the stuff that I was agreeing to, I wasn't really,
Nothing further, Your Honor.
Okay. Mr. Solis, you're going to have an opportunity to testify right now. I know it's kind of weird, but do you have anything to state on cross-examination in
I do
relation
not.
to what Ms. Bocher just told you? Okay.
No, I do not.
All right. Ms. Bocher, do you have any other evidence or witnesses to present?
That's all, Your Honor. Thank you.
Okay. Now, it goes to you, Mr. Solis. You
Yes.
are able to testify, should you choose to, in a narrative form. Just tell me what you want to say about the motion. Ms. Bocher will have an opportunity to cross-examine you after that.
Okay. Well, as far as, you know, this motion with all the exhibits that they showed, I do note that the last time I spoke to her attorney, she says that, you know, she wanted $10,000 by by March 22nd. And if I gave her those $10,000, that they would just, you know, stop the filing of the motion and just, you know, just give her the 10,000 and they'll stop the filing and just keep the payments. And I told her that I wasn't able to give her $10,000. I could probably give her 5,000 and then I can up the payment to $800 a month. And then I can, you know, if they go into the judgment, if they file for the judgment on the money, then settle up on an amount, and then I can just try to pay it off as soon as, you know, the faster that I could. That's it.
Okay. Anything else?
I do know that I do have a check made up to FLSDU for $4,300 right now, cashier's check already made up today already. That I thought I could go to the courthouse and pay for it, but they told me I had to mail it in. So I am, you know, I do want to get this resolved. I do want to pay her money and, you know, get it done with, but not at the motion at the time that they want.
Okay. Anything else, Mr. Solis?
No.
Okay. Ms. Bocher, do you have any cross-examination?
Nothing. Thank you.
Okay. Mr. Solis, do you have any other evidence or witnesses to present?
Well, just the one last thing that I was going to say about their request. Basically, now that she wants me to pay for her attorney fees, I was truthful when I told her that, you know, they can have she can see on my bank accounts and she can see that I have not made any judgments or any withdrawals or anything as far as what's in the bank prior to me getting this letter. So everything has been staying the same. And then, you know, they can get all the payroll records they want and that's it. But I do not want to keep on adding my, you know, bill with her, because every time they look at a document, I'm getting charged. And now I just don't want to, you know, I don't want to add any more attorney fees that I can just pay her and then, you know, get this done with.
Okay. Ms. Bocher, that was additional direct testimony. Do you have any cross-examination based on that?
Mr. Solis, you recall that we sent you a request to produce, requesting your bank records and your payroll records, correct?
Yes, and then I called you and I was truthful when I say I haven't made anything and I haven't made any movements or anything with my account, with my bank account, so that I'm being honest with that. And then for me to say, okay, here's this paperwork, and then you charge me another $300, $500 to read a paper that I'm telling you, it just doesn't seem right with me, just to go ahead and just pay the amount to her and then not keep on adding all this. I don't want to get an attorney because I just want to pay the money to her. I'd rather pay her, you know, I'm being truthful with everything that I say. I'd rather just pay her. I don't want to hire an attorney, and I don't want to keep on adding your bills up if she wants me to pay for that.
Did you actually provide me with the bank statements and payroll records that I requested?
I did not.
Nothing further, Your Honor.
Okay. Mr. Solis,
Yes.
Any more testimony in relation to what Ms. Bocher just asked you about?
No.
Okay. All right. The court has heard all of the evidence here today. Ms. Bocher, can you briefly discuss what it is that you're seeking as a result here? And also, I want to kind of understand what's your position relating to contempt, as I know I would have to, for some of the issues, determine an ability to pay. I don't know if we're there yet.
1 second, Your Honor. I do want to note that she has been paying. Payments have been made.
Mr. Solis, this is Ms. Bocher's time to speak. You're going to have an opportunity to speak afterwards.
Okay.
Summation.
So, Your Honor, clearly, as far as his ability to pay, there's a couple things. First of all, he clearly had the ability to pay $13,000 when he voluntarily entered into the agreement in September of 2018. We requested a current financial affidavit. We requested documents related to his income, bank accounts, those things. Those were not provided. So he has not provided any indication that he does not have an ability to pay. And I think the court should again take notice of this September 2018 order that he voluntarily entered into. Clearly he had that ability to pay at that point. So she's asking that the purge amount be set at $13,000, which is the amount that he agreed to pay and did not pay. And then asking the court to enter a money judgment for the remaining amount. This has been dragging on for years prior to September 2018, but that was the most recent, and that's been nearly 3 years, 2.5 years, I guess. The child, as I said, has emancipated. And I think it's clear she's established that there's a prior order that directed payment of support. There was a prior order directing payment of the purge amount. The earning income withholdings orders that were supposed to increase his payments were not entered. I don't know why. I was not involved in the case at that time. And as my client testified, she doesn't know either. So she's established all the requirements. He's done nothing. He's provided nothing to show that he does not have an ability to pay. And she's certainly entitled to the relief she's requesting, including her attorney's fees. We would not be here but for his non-compliance.
Okay, Mr. Solis, you wanted to speak a little
Yes.
bit more? I interrupted you because you had interrupted.
Okay. I'm sorry about that. Okay, when I first went into that agreement with her past attorney, I was told that I had till Friday to sign that agreement. If not, that she was gonna get the cops involved and all this bunch of stuff. And I said I was gonna get an attorney, and she said, well, you got till Friday to sign this paper. Now she's gonna file other stuff. So that was the reason I went into the motion. As far as the $13,000 that I went into that, I have spent on Cameron alone an excess amount of like $12,000 of situations that came when before he was 18. And then if she wanted to get this resolved for the last 3 years, then why did she ask to get an extra year of child support that he wasn't even living with her? So why did she ask another year? I didn't even know if, I'm not an attorney, but I don't know if that's even is something that you can just do because the child was over 18.
Okay. All right. Anything else, Mr. Solis?
No.
All right.
Oh,
so here's what I'm sorry, Mr. Solis.
Okay.
Yeah, did I interrupt you?
Well, no.
Okay. All right. So, Ms. Bocher, a couple things I think are easy calls and really should be ordered and will be ordered. First of all, obviously, we can enter the money judgment on behalf of the wife, as there was no evidence. The evidence you presented about the money judgment was basically uncontroverted by any substantial incompetent evidence. So you can enter an order granting that, also granting your motion to the extent of enforcement. Also, as a result of having to bring this, I will grant the request for attorney's fees as to the amount is supported in the affidavit, as the court finds that your hourly rate was reasonable and the amount of time was also reasonable and uncontroverted based on the evidence today. I'm a little bit more concerned about holding him in indirect civil contempt at this point, considering he is stating that he doesn't have the money. And I don't know how I would be able to set a purge yet if that is actually the case. It seems like maybe the better course here is to have you complete the motion to compel, get his financials, and then based on that, maybe we can set a show cause hearing. Because I think what you're going to be eventually asking me to do is whether or not I should be holding him in indirect civil contempt and potentially incarcerating him until he pays the amount. And I'm not willing to do that right now until I know more about his financials, or at least he has the opportunity. I can see the request for production was filed in March, and yeah, he's late and hasn't done it yet, and he needs to. I know that you have filed a motion to compel on that, but I want to see how that plays out before we determine whether or not the court needs to take more drastic actions than just the judgment and the attorney's fees award here. As far as the other things that you're requesting, again, but based on the fact that I don't feel comfortable right now saying that he has the ability to pay. At this point in time, I'm not going to suspend his driver's license, order him into community service or any type of incarceration. But that type of request might be coming depending on what happens in the not too distant future. So, Ms. Bocher, I'm going to be asking you to prepare the order of obviously granting your request as far as the money judgment and attorney's fees. Is the motion to compel set?
No, because we knew we couldn't get it set before the hearing, before this hearing.
Okay.
So I'll have my paralegal get that scheduled.
Okay. We can get that scheduled as soon as possible because we may have to have a show cause hearing. Mr. Solis, in the interim, so what's happened today? Do you understand the court's order today, Mr. Solis?
Yes. And I do want to note something if I'm available to do that right now.
Yes.
Okay. So once she gets, I give her, I request my payroll stuff from my employer. And once she gets my bank account, and then you see that what I said right now is truthful, is that going to impact my ability not to pay her attorney fees? Like, because at this point.
Well, so first of all, I'm not able to give you legal opinions here today, okay. But the attorney's fees today is no impact on that. Okay. That is based on that is based on basically her filing a valid motion for enforcement that really had no basis to be objected to, and I don't even really quite understand from the testimony whether it was objected to. So no is the answer to that question as it relates to what just happened today. Okay. But here's what you need to do, and this is not legal advice. This is clearly there's a motion to compel your financial information that's outstanding. We're going to be having a hearing on that. Now, if you produce all of the financial information, then there may not be anything to compel, but you haven't done it yet. And understood. You're asking Ms. Bocher just to take your word right now that you have no money. And understood. Especially given the history of having entered into a settlement agreement that required you to pay $13,000 and you paid $0, and that was 2 years ago. Okay. So, well, like I said, I have a check, cashier's check that I am mailing today for $4,300. From now until the hearing, I will see how much more money I can come up when we have the next hearing, and then I guess we go from there. That sounds like a good start. Be in contact with Ms. Bocher, and maybe you all can resolve this before you come back in front of me. I have tried to contact her and her paralegal. I have already tried to make 3 phone calls, which they said they will return phone call, and so far I have not been returned any phone calls from them. Okay, well, I know from experience, Ms. Bocher will talk to you and we'll eventually call you back. I'm not too concerned about that, although it may not be immediate. Okay, no problem. Right. So I'm gonna just go ahead, do what you just said right now, and then continue to try to make this $13,000 the less money for the next time we see each other. Okay. I mean, we hear each other. Sounds good. Ms. Bocher, as it relates to indirect civil contempt, you can just say the court's reserving on it. Reserving on it? Okay, perfect. Okay. All right. Any questions? No, Your Honor, thank you. Would I be, so I'm just gonna go ahead and get this paperwork over to her, and after that, I would just be getting an email for the next hearing? You'll receive notice whenever there's another hearing. Nothing scheduled right now. All right. Thank you all. Thank you, Your Honor. Appreciate it. Bye, Ms. Dines. Good morning, Ms. Malie.
Good morning, Your Honor.
We're here in the case of Rodriguez versus Ramsey, 20 DR 2296. Please enter your appearance, Ms. Malie.
Anna Million on behalf of Gabriela Rodriguez de Roca, the petitioner.
Okay.
Yes.
Is that your client right there?
I don't see anyone.
LG Stylo 6. Are you able to see?
Okay.
Do you want me to ask her?
Can you please ask her, because I've never seen her before.
Yeah. Señora, ¿usted es Gabriela Rodríguez?
Sí.
Sí.
Soy yo.
Okay.
Excellent. So I take it she will be requiring the use of the interpreter.
Yes, and I have 11 Cruz as my interpreter.
Thank you very much for your services today, Ms. Cruz.
Thank you.
All right. Ms. Moline, is there any reason we shouldn't proceed to final judgment in this case?
There's no reason, Your Honor.
All right. In that case, Madam Clerk, can you please swear in Ms. De Roca?
Please raise your right hand.
Señora Roca, si puede levantar su mano derecha.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
¿Usted jura que el testimonio que va a dar es la verdad, toda la verdad y nada más que la verdad?
Sí, juro.
Okay, can you please state your name and date of birth for the record?
Okay, ¿puedes decir su nombre y su fecha de nacimiento para la corte?
You can put your hand down.
Oh, puede bajar su mano.
Sí. Gabriela Rodríguez de Roca, Saavedra de Roca. No, perdón, Gabriela Rodríguez de Roca, 3 de diciembre del 77.
Gabriela Rodríguez de Roca, December 3rd of 1977.
Okay, please proceed, Ms. Moline.
Thank you, Your Honor. Ms. De Roca, may you please state the name of the respondent?
Señora Rodríguez, ¿puede decir el nombre del demandado?
Jarvis Ramey.
Ms. De Roca, when were you and the respondent married?
Señora, ¿cuándo usted y el demandado se casaron?
El 15 de enero del 2020.
January 15th of 2020.
And when were you and the respondent separated?
¿Y cuándo estaban separados usted y el demandado?
Como el 10 de febrero.
About the 10th of February.
Very good. Ms. De Roca, are you over the age of 18?
Señora De Roca, ¿usted tiene más de 18 años?
Sí.
And from your knowledge, do you know if the respondent is over the age of 18?
¿Y a su conocimiento, el demandado tiene más de 18 años?
Sí.
Are you, either you or the respondent in the military?
¿Usted o el demandado están en las Fuerzas Armadas?
No.
Have you resided in the state of Florida 6 months prior to the filing of this petition?
¿Usted vivía o vivió en el estado de la Florida por 6 meses antes de presentar esta petición?
Sí.
Ms. De Roca, are you currently pregnant?
Señora De Roca, ¿usted en este momento está embarazada?
No.
And do you and the respondent have any children together who are under the age of 18?
¿Y usted y el demandado tienen hijos en común que tienen menor de 18 años?
No.
Very
No
good.
tenemos.
Do you have any marital asset or debt that you're asking the court to distribute today?
¿Usted tiene bienes o deudas que está pidiendo entre el matrimonio que usted está pidiendo que esta corte distribuye?
No.
And is that your wish to have alimony waived from this marriage, Ms. Daroca?
¿Y es su deseo a renunciar la pensión alimenticia de este matrimonio?
Sí.
Is that your testimony that the marriage is irretrievably broken?
¿Y eso es su testimonio que el matrimonio está roto?
Sí.
The court heard the petitioner's testimony, Your Honor, and asked that in order to dissolve the marriage and restore Ms. Daroca to her single status be entered.
Is she also seeking a name change?
No, Your Honor.
Okay. There was a, in the final judgment that was submitted to the court, it talks about a name change in paragraph 8.
Oh.
Could you please take a look at that and submit to me an updated final judgment? So
Yes, I will do that.
I do have one question.
Yes, Your Honor.
Are the dates right here? It seems she got married on January 15, 2020 and was divorced just 25 days later?
Yes.
Or they're separated 25 days later?
Yes.
Ms. DeRoca, what was the reason, what was the cause for the separation?
Señora De Roca, ¿qué era la causa por la separación?
Porque en 2 ocasiones él me agredió y en la segunda casi me mata, entonces prefiero separarme.
Okay. It was on 2 occasions that he got aggressive with her, and on the second occasion, he almost killed her. So she would prefer separate or divorce.
Okay. All right. The court has heard all of the evidence and the testimony and finds that it's jurisdiction over the subject matter and the parties. At least one party has been a resident of the state of Florida for 6 months prior to filing this petition. That the marriage is irretrievably broken without any minor children and without any marital assets or liabilities to divide. The court will therefore dissolve the marriage and restore the parties back to single status. And as soon as I get an updated final judgment from Ms. Moline, I will sign it and officially dissolve the marriage. Best wishes to you, Ms. DeRoca, in the future. That was a lot to translate, Ms. Cruz. Do you want me to do it again?
I can just tell her that she's.
I'll tell you if you missed anything.
Yeah, no. Can you do a little again?
The court finds that it has jurisdiction over the subject matter and the parties.
Okay, que la corte encuentra que ellos tienen jurisdicción sobre el caso y las partes.
That at least one party has been a resident of the state of Florida for 6 months prior to filing this petition.
Y que por lo menos de una parte ha sido residente del estado de la Florida por 6 meses antes de la presentación de esta petición.
In that the marriage is irretrievably broken without any minor children and without any marital assets or liabilities to divide.
Y que el matrimonio está roto sin hijos en común menores de edad y sin bienes y raíces o deudas que no se necesitan de distribuir.
The court will therefore dissolve the marriage and restore the parties back to single status.
Y la corte va a terminar el matrimonio y le va a dar el estatus de mujer soltera.
Okay.
And as soon as I receive an updated final judgment, I will sign that and make it official.
Y cuando la abogada le mande un juicio final al juez, él lo va a firmar y para hacerlo final.
Sí, está bien.
Best wishes to you, Ms. DeRoca, in the future.
Y buena suerte, señora Roca, en el futuro.
Thank you.
Do you have any questions, Ms. Moline?
No, I don't, Your Honor. I will go ahead and send that to Ms. Cheyenne as soon as possible. Thank you so much.
Thank you very much. Have a great afternoon, everyone.
Thank you, Your Honor.
Thank you.
Bye. And thank you, Ms. Cruz, for your help.
Thank you. You're welcome.
Thank you.
All right, Stephanie, I will see you at 1:15.
All right, I'll see you then.